open to review. But I don't want to be misunderstood about this. I share the view. I share the view that depending on where you live in this state, a car is a necessity for people. For some, it's a necessity for social interaction and contact with family and friends. For others, it's essential to their getting to work and to their getting their children to school. And we've taken that into account in this context. There has to be a balance, and in the context of that balance, I can't accept the amendments that have been tabled.
Thank you, Minister. Now, we're dealing with Shadow Amendment number 31 and amendments there too. And amendment number 1 in the name of Deputy Park McLaughlin, that's already discussed 25, and I now put the question that the amendment to the amendment be made. Those in favour of Abhinish. Those against? I believe the amendment is lost. I now put the question to the main amendment that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 32, as already discussed, number 25. And again, we have an amendment to the amendment, number 1, in the name of Deputy Park McLaughlin, as already discussed, 25. And I put the amendment, that the amendment to the amendment be made. Those in favour of Abhinish. Those against? I believe the amendment is lost. I now put the question on the main amendment as follows, that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 33 is already discussed with number 5, that the Shannon amendment be agreed to. Is that agreed? Shannon amendment number 34, as already discussed with number 23, that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 35, as already discussed with 25, that the Shannon amendment be agreed to. Is that agreed? Agreed. Excuse me. Shannon amendment 36, number 36, as already discussed with number 10. The question that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 37, as already discussed with number 23, that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 38, as already discussed with number 5, that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 39, as already discussed with number 25, that the Shannon amendment be agreed to. Is that agreed? Agreed. Shannon amendment number 40. Number 40, 41, 54, 55, 58, 59, 170 and 180 are related and will be discussed together. That the Shannon amendment be agreed to. Is that agreed? Agreed. Number 40. Yes, yes. We deal with number 40 and related amendments. Number 40, 41, 54, 55, 58, 59, 170 and 180. The related and will be discussed together.
Yeah, perhaps if I just deal with these. These amendments provide for situations where an approved intermediary or personal insolvency practitioner resigns or becomes unable to act and a replacement intermediary or practitioner is appointed. Amendment number 40 improves the text of the provisions of section 25 dealing with situations where an approved intermediary resigns or otherwise becomes unavailable to continue acting as such for the debtor. Essentially, the required notifications to be made by the parties concerned are set out in clearer fashion. Subsection 10 now provides that if an approved intermediary resigns from the role in respect of a debtor, the intermediary shall be required to notify the Insolvency Service. A replacement approved intermediary must inform the Insolvency Service of his or her appointment. I'd ask that the House here note a slight correction of alignment in amendment number 40, which is that in the new subsection 10, the text after paragraph D should be aligned to subsection level. If I could just point that out, and that will require dealing with when the bill is printed in final form. Amendment number 54 amends the existing provision so as to empower the Insolvency Service to prescribe the criteria for authorisation of persons as authorised intermediaries. Amendment 55 provides the authorisation of a person to act as an approved intermediary may be withdrawn as provided for in regulations which, when they no longer meet the criteria for authorisation. Amendment 58 replaces subsections 4 to 6 of section 46 with new text regarding notification and reporting responsibilities in relation to the resignation and replacement of personal insolvency practitioners. These amendments are required to improve the overall presentation of the section for clarity and for consistency of approach with the amendments to section 25 regarding approved intermediaries. Amendments 41, 59, 170, 180 are technical drafting amendments to further refine the text.
Margaret, Shannon Amendment 40 agreed? Agreed. Shannon Amendment 41 already discussed with 40. Is that agreed? Agreed. Shannon Amendment 42 already discussed with 3. Is that agreed? Agreed. Shannon Amendment 43 already discussed with 25. Is that agreed? Shannon Amendment 44 already discussed with 3. Is that agreed? Shannon Amendment 45 already discussed with 25. Is that agreed? Shannon Amendment 46 already discussed with 25. Is that agreed? Agreed. Shannon Amendment 47 already discussed with 25. Agreed? Agreed. Shannon Amendment 48 already discussed with 25. Is that agreed? Agreed. Shannon Amendment 49 already discussed with 25. Is that agreed? Agreed. Shannon Amendment 50 already discussed with 25. Is that agreed? Agreed. Shannon Amendment 51 already discussed with 25. Agreed? Agreed. Shannon Amendment 52 already discussed with 25. Is that agreed? Agreed. Shannon Amendment 53 already discussed with 1. Is that agreed? Agreed. Shannon Amendment 54 already discussed with 40. Is that agreed? Agreed. Shannon Amendment 55 already discussed with 40. Is that agreed? Agreed. And Shannon Amendment 56, 57, 61, 63, 65, 66, 67, 117, 118, 120, 121, 122, 177, 178 and 179 are related and will be discussed together. Minister, on that amendment.
Let's start with amendment number 56. These amendments address matters relating to an application for a protective certificate in the debt settlement arrangement and personal insolvency arrangement processes. Number 56 substitutes the existing text of section 46(1) with new text regarding the information which the debtor is required to provide to the personal insolvency practitioner in relation to his or her financial affairs. It also now includes a requirement for the disclosure of details of any guarantees given by the debtor. The amendment is intended to improve the clarity of the provision. Amendment 57 is a technical drafting amendment to further refine the text to include a reference to the provision of the personal insolvency practitioner's advice in writing. The purpose of Amendment 61 is to make clear that where the advice of the personal insolvency practitioner is that a debtor should not make a proposal for or enter into an arrangement, the personal insolvency practitioner is required to notify the insolvency service of that fact, and the appointment of the personal insolvency practitioner comes to an end. Section 63 inserts a new subsection 3 in section 53 to provide that a proposal for debt settlement arrangement should only concern debts which are in default for a period of more than 6 months prior to the application. Amendment 118 provides for a similar amendment to be made to section 88 in relation to a proposal for personal insolvency arrangement. Amendment 65 extends the provisions of section 54 to subsection 2e with new text to provide that the schedule of debts and creditors must accompany an application for a protective certificate relating to a proposal for debt settlement arrangement should also contain any other information that may be prescribed. Amendment 120 provides for a corresponding amendment to section 89(2)(e) regarding an application for a protective certificate relating to a proposal for a personal insolvency arrangement. Amendment number 66 inserts 2 new subsections in section 54 to improve the text. The new subsection 3 provides that an application for a protective certificate may be withdrawn by the personal insolvency practitioner at any time prior to the issue of the certificate. This is not made clear in the bill as it currently stands. The new subsection 4 places an obligation on the personal insolvency practitioner to notify the insolvency service as soon as practical after he or she becomes aware of any inaccuracy or omission in relation to an application for a protective certificate. The insolvency service is required to have regard to any such information provided under subsection 4 for the purposes of its consideration of the debtor's application. Amendment 121 provides for the same amendments to be made to section 89 in relation to the personal insolvency arrangement. Amendment 67 will replace the current section 56 with improved and extended text regarding the process whereby the insolvency service refers an application for a protective certificate in respect of a debt settlement arrangement to the court. The new elements concern situations where the insolvency service is dissatisfied with the application and may require a revised application where a court requires further information. Where a court decides to hold a hearing may hold it otherwise than in public. Amendment number 122, similar in purpose to Amendment number 67. It proposes the replacement of Section 91 in relation to the process for referring an application for protective certificate in respect of a personal insolvency arrangement to the court. Amendment 117 removes the requirement for a debtor applying for personal insolvency arrangement to make a statutory declaration as to his or her cooperation with secured creditors in relation to the principal private residence and replace it with a requirement for a declaration in writing. Present Section 131 requires the Minister for Justice and Equality to prescribe the form of the prescribed financial statement to be used in applications for the new debt resolution processes provided for in the bill. For flexibility, Amendments 177 and 178 propose instead that the Insolvency Service should carry out this function. Amendment 179 is basically a technical drafting amendment to improve the presentation of Section 131.
Question then is that Shannon Amendment 56 be agreed. Is that agreed? Agreed. Shannon Amendment 57, already discussed at 56. Is that agreed? Agreed. Shannon Amendment 58, already discussed with 40. Agreed? Agreed. Shannon Amendment 59, already discussed with 40. Is that agreed? Agreed. Shannon Amendment 60, already discussed with 5. Is that agreed? Agreed. Shannon Amendment 61, already discussed with 56. Is that agreed? Agreed. Shannon Amendment 62, already discussed with 3. Is that agreed? Agreed. Shannon Amendment 63, already discussed with 56. Is that agreed? Agreed. Shannon Amendment 64, already discussed with 3. Is that agreed? Agreed. Shannon Amendment 65, already discussed with 56. Is that agreed? Agreed. Shannon Amendment 66, already discussed with 56. Is that agreed? Agreed. Shannon Amendment 67, already discussed with 56. Is that agreed? Agreed. On Shannon Amendment 68, 68, 69, 71, 82, 92, 93, 123, 124, 126, 127, 146 and 147 are related and will be discussed together by agreement. I call on the Minister.
The group starting with number 68.
68.
These amendments seek to improve the provisions of the bill relating to the effect of a protective certificate or the approval of a debt settlement arrangement or personal insolvency arrangement. Amendments number 68 and 123 refine the text of sections 57 and 92 to better clarify the effect of the issue of a protective certificate in a debt settlement arrangement or personal insolvency arrangement. Amendment 69 makes it clear that a secured debt is not affected by a protective certificate in the debt settlement arrangement process. Amendment 71 is required to improve the current formulation of section 59(1). It also includes a new provision which requires the personal insolvency practitioner to make a proposal for debt settlement arrangement in addition to inviting submissions from creditors. Amendments 126 and 127 provide for corresponding amendments to section 94 regarding the personal insolvency arrangement. Amendment 82 is a technical drafting amendment which amends the existing text of section 63 to include a necessary cross-reference section 57. Amendments 92 and 146 refine the text of section 74 and 112 in relation to the effect of an approved debt settlement arrangement or personal insolvency arrangement on creditors. Amendments 93 and 147 aim to clarify the position in those sections in relation to creditor action against another person who may have guaranteed the specified debts concerned. The purpose of Amendment 124 is to delete section 92(8), which is now redundant following the amendments regarding excluded and excludable debts.
The question then is that Shannon Amendment 68 be agreed. Agreed? Agreed. Shannon Amendment 69 already discussed with 68. Is that agreed? Agreed. Shannon Amendment 70 already discussed with number 1. Is that agreed? Agreed. Shannon Amendment 71 already discussed with 68. Is that agreed? Agreed. Shannon Amendment 72 already discussed with number 1. Is that agreed? Agreed. On Shannon Amendment 73, 73, 86 to 88 inclusive, 90, 96 to 100 inclusive, 137 to 144 inclusive, 151 to 154 inclusive, and 182 are related and will be discussed together. So I call the Minister.
This group of amendments deals with procedures for creditors' meetings relating to proposals for debt settlement arrangement or personal insolvency arrangement, court approval of a DSA or PIA, and also with procedures for variation of such arrangements. Amendment 83 provides for more specific reference to the documents required to be given to the creditors prior to a creditors' meeting to consider a proposal for a debt settlement arrangement. The amendment also makes it clear that where a creditors' meeting does not take place for the expiry of the protective certificate, the debt settlement arrangement procedure should be deemed to have come to an end. Amendments 84, 85, 86, technical drafting amendments to provide for correct cross-referencing consequential to Amendment 40. Amendments 137, 138, 139 provide for corresponding amendments to the provisions relating to creditors' meetings regarding proposals for personal insolvency arrangements. Amendment number 87 proposed to replace section 67(3) with new text in order to make the provisions consistent with similar provisions in the bill, such as those in section 65(2). It also provides that where an amended debt settlement arrangement proposal is prepared, the personal insolvency practitioner should also be required to furnish this proposal to the Insolvency Service. Amendment 142 will make a corresponding amendment to section 105(5), which applies to amended proposals for personal insolvency arrangements. Amendment number 88 clarifies that the voting rights exercisable by a creditor at a meeting of creditors to approve a debt settlement arrangement are in proportion to the amount rather than the value of the debt due to that creditor on the day the protective certificate is issued. This is a better expression of the likely situation. Amendment 140 replaces the current section 104 of the bill in order to set out in a clear fashion all of the relevant factors in regard to the determination and exercise of voting rights at creditors' meetings in regard to a personal insolvency arrangement. Amendment 141 is a technical drafting amendment. 143 replaces the current text of section 106 with regard to the proportion of creditors required to approve a personal insolvency arrangement. The purpose of the amendment is to clarify the operation of the section. The section has been shortened to reflect the key point, which is the percentage of votes in total and in the secured and unsecured classes. Some other provisions of the section have been relocated to the revised section 104, proposed by Amendment 140. Amendment 182 proposes to insert a new section in Chapter 6. It sets out how debts in other currencies are to be dealt with in the context of the provisions of the bill. There are specific references to a foreign currency in Section 68(3) and Section 104(2). However, I am advised it would be more appropriate to delete these references and to provide a general currency conversion provision applicable to the three new debt resolution processes instead, and this is what we're doing. Amendments 90, 144 replace the provisions of sections 73 and 111 in regard to the approval by a court of a debt settlement arrangement or a personal insolvency arrangement. The text of the sections, while not altered substantially, is now presented in a more coherent fashion in regard to the satisfaction of the eligibility criteria for the Insolvency Service and the Court. Regarding the variation of debt settlement arrangements and personal insolvency arrangements, Amendment 73 is consequential on Amendment 100, which will delete Section 78 of the Bill. The section provided for the process of termination of a debt settlement arrangement by a meeting of creditors. On further reflection, the Attorney-General's Office and Parliamentary Council has proposed that the section be deleted on the basis that it is not particularly required in the light of the provisions of Section 79, which require the involvement of the Court. There is no comparable provision in the personal insolvency arrangement. Amendments 96 and 151 are required to ensure consistency between the debt settlement arrangement and personal insolvency arrangement provisions of the bill in relation to the variation of either type of arrangement. These amendments address inconsistencies between Section 79 concerning the debtor's consent to a variation of a debt settlement arrangement and the corresponding Section 115 concerning consent to the variation of a personal insolvency arrangement. Amendment 97 removes the discretion previously afforded to the personal insolvency practitioner in regard to the calling of a creditors' meeting to consider a possible variation in a debt settlement arrangement. Amendments 98, 99, 152, 153 and 154 aim to clarify the procedures for voting by creditors on a proposed variation of a debt settlement arrangement or a personal insolvency arrangement.
Good Margaret. Question then is that shall Amendment 73 be agreed to? Agreed. Amendment 74. Shall Amendment 74, is that agreed? Already discussed with number 1. Agreed. Agreed. Shall Amendment 75 already discussed with number 3 is agreed. Agreed. Shall Amendment 76 already discussed with number 3 agreed. Agreed. Shall Amendment 77 already discussed with 23 agreed. Agreed. On Shall Amendment 78, 80, 81, 89, 130, 132 and 133 are related and will be discussed together. So I call on the Minister.
This group of amendments deals with the treatment of preferential debts in the debt settlement arrangement and personal insolvency arrangement processes. Amendments 78 and 130. Are technical amendments to sections 61 and 96 to insert cross-references to the sections dealing with preferential debt and debt settlement arrangement or a personal insolvency arrangement. Amendment 80 replaces the existing text of section 62(1) with revised text which makes clear that unless the creditor concerned otherwise agrees in writing and provision to that effect is made in the terms of the debt settlement arrangement, a preferential debt is to be paid in priority by the debtor. Amendment 81 proposes the insertion of an interpretation provision in relation to preferential debt. Amendments 132 and 133 make corresponding amendments to section 97, which relates to preferential debt for purposes of the personal insolvency arrangement chapter. Amendment 89 replaces subsections 3, 4 and 5 of section 68 with one new subsection 2. The provisions in subsections 3 and 4 have been addressed by amendments 76 and 182. The provisions of the previous subsection 5 relating to preferential debt in relation to proposal for debt settlement arrangement have been further refined in the new subsection 2.
Margaret there. Question is that Shannon Amendment 78 be agreed to. Is that agreed? Agreed. Shannon Amendment 79 already discussed at 3. Is that agreed? Agreed. Shannon Amendment 80 already discussed at 78. Is that agreed? Agreed. Shannon Amendment 81 already discussed with 78. Is that agreed? Agreed. Shannon Amendment 82 already discussed with 68. Is that agreed? Shannon Amendment 83 already discussed with 73. Is that agreed? Agreed. Shannon Amendment 84 already discussed with 73. Is that amendment agreed? Agreed. Shannon Amendment 85 already discussed with 73. Is that amendment agreed? Agreed. Shannon Amendment 86 already discussed at 73. Is that agreed? Agreed. Shannon Amendment 87 already discussed at 73. Is that agreed? Agreed. Shannon Amendment 88 already discussed at 73. Is that agreed? Agreed. Shannon Amendment 89 already discussed at 78. Agreed? Agreed. Shannon Amendment 90 already discussed with 73. Is that agreed? Agreed. Shannon Amendment 91 already discussed with number 1. Is that agreed? Agreed. Shannon Amendment 92 already discussed with 68. Is that agreed? Agreed. Shannon Amendment 93 already discussed with 68. Is that agreed? Agreed. Shannon Amendment 94 already discussed with number 1. Is that agreed? Agreed. Shannon Amendment 95 already discussed with number 1. Is that agreed? Agreed. Shannon Amendment 96 already discussed with 73. Is that agreed? Agreed. Shannon Amendment 97 already discussed with 73. Is that agreed? Agreed. Shannon Amendment 98 already discussed with 73. Is that agreed? Agreed. Shannon Amendment 99 already discussed with 73. Is that agreed? Agreed. Shannon Amendment 100 already discussed with 73. Is that agreed? Agreed. On Shannon Amendment 101 to 105 inclusive, 108, 110, 156, 161, 162 and 163 are related and will be discussed together. So I could ask the Minister to...
These amendments deal with situations where a creditor or personal insolvency practitioner wishes to challenge the coming into effect of a debt settlement arrangement or a personal insolvency arrangement, but have such an arrangement terminated in accordance with the Bill. Amendments 101 and 108 are technical drafting amendments to insert necessary cross-references into section 7984. Amendment number 102 clarifies in the context of a court's consideration for the application for termination of a debt settlement arrangement at what point in time the eligibility criteria were not met. Amendment number 103 is a technical drafting amendment to improve the presentation of the bill. Amendments number 104 and 161 provide for a clearer expression of what constitutes a period of arrears for the purpose of an application to the court by a creditor or personal insolvency practitioner for termination of a debt settlement arrangement or a personal insolvency arrangement on the grounds the debtor is in arrears with his or her payments for at least 3 months. Amendments 105 and 162 would ensure that the debtor also will be given notice by the personal insolvency practitioner of the termination of a debt settlement arrangement or personal insolvency arrangement due to a 6-month arrears default. Amendments 110 and 156 are technical drafting amendments to sections 84 and 116 to make it clear that a creditor may only challenge a debt settlement arrangement or personal insolvency arrangement on the grounds that the debtor has committed an offence if the offence in question has caused a material detriment to the creditor. The purpose of Amendment 163 is to define in section 118 where a 6-month arrears default takes place. The new subsection affects the text of section 80, subsection 3, which defines a 6-month arrears period for the purpose of a debt settlement arrangement.
Margaret there. Question then is that shall the Amendment 101 be agreed? Agreed. That shall the Amendment 102 already discussed at 101? That agreed? Agreed. Shall the Amendment 103 already discussed at 101? Agreed? That agreed? Agreed. Shall the Amendment 104 already discussed with 101? Is that agreed? Agreed. Shall the Amendment 105 already discussed with 101? Is that agreed? Agreed. Shall the Amendment 106 already discussed with number 1? Is that agreed? Agreed. Shall the Amendment 107, 107, 185 to 191 inclusive, 193 to 201 inclusive are related and will be discussed together? I will call on the Minister.
Amendment 107 proposes the deletion of section 82, which provides that a terminated debt settlement arrangement under sections 78, 79 or 80 are to be deemed acts of bankruptcy. These are now listed in Amendment 186, which inserts them into the appropriate section in the Bankruptcy Act 1988. Amendment number 185 inserts the definition of trustee for the purpose of interpretation. Amendment number 186 amends section 7 of the Bankruptcy Act 1988 to provide that a failed or terminated debt settlement arrangement or personal insolvency arrangement will be included in the list of acts of bankruptcy. Amendments 187 and 188 are technical drafting amendments to improve the text of the bill. Amendment number 189 empowers the court to order the attendance of the debtor at the court hearing of the adjudication of the creditor's petition for his or her bankruptcy and to make a full disclosure of assets and liabilities. This provision corrects a gap in the present legislation. Amendment 190 is a technical drafting amendment to section 139 of the bill, which replaces section 15 of the Bankruptcy Act to add a reference to the requirements of section 11 of that Act being fulfilled. Amendment number 191 is a technical drafting amendment to improve the presentation of the bill. Amendment 193 provides for the ending of applications for payments by the bankrupt under section 65 in favour of the approach to bankruptcy payment orders now provided under Amendment number 200. It also provides for the continuation and possible variation of an existing payment order under section 65. Amendments 194 to 198 are essentially drafting amendments to improve the text by providing for the issue of a certificate of discharge or annulment in a bankruptcy to make a necessary reference to a trustee in bankruptcy, the sections of the Bankruptcy Act 1988 concerned. Amendment 200 substitutes and improves the current text in section 146 of the bill, inserting section 85D to the Bankruptcy Act in regard to bankruptcy payment orders, which may, if the debtor's circumstance permit, be sought. The court, in deciding on such orders, will have regard to the reasonable living expenses of the bankrupt, his or her dependents. Amendment 201 updates the time period in section 123 of the Bankruptcy Act with regard to potentially fraudulent actions from the present 12 months to now standard period in this bill of 3 years.
The question is that shall Amendment 107 be agreed to? Agreed. Shall Amendment 108 already discussed with 101? Is that agreed? Agreed. Shall Amendment 109 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 110 already discussed with 101? Is that agreed? Agreed. Shall Amendment 111 already discussed with number 10? Is that agreed? Agreed. Shall Amendment 112 already discussed with 10? Is that agreed? Agreed. Shall Amendment 113 already discussed with number 10? Is that agreed? Agreed. Shall Amendment 114 already discussed with number 5? Is that agreed? Agreed. Shall Amendment 115 and 184 are related and will be discussed together? I call on the Minister.
This group of amendments deals with the review of the bill after its enactment. Amendment 115, which proposes the deletion of section 85, is consequential on the new review section inserted by Amendment 135A. Amendment number 184 revises the original review provision in regard to the operation of the bill. That review, which will now encompass the 3 new debt resolution processes in Part 3, will commence no later than 3 years after commencement and be completed within a year. However, as I said when we discussed this point previously, the operation of this bill will be subject to ongoing review. I've made it clear I will swiftly intervene with amending legislation to make additional provision or to correct any error that arises from operational experience.
The question then is that shall Amendment 115 be agreed? Agreed? Agreed. Shall Amendment 116, already discussed at number 3, is that agreed? Agreed. Shall Amendment 117, already discussed at 56, is that agreed? Agreed. Shall Amendment 118, already discussed at 56, is that agreed? Agreed. Shall Amendment 119, already discussed at number 3, is that agreed? Agreed. Shall Amendment 120, already discussed at 56, is that agreed? Agreed. Shall Amendment 121, already discussed at number 56, is that agreed? Agreed. Shall Amendment 122, already discussed at 56, agreed? Agreed. Shall Amendment 123, already discussed at 68, is that agreed? Agreed. Shall Amendment 124, already discussed at 68, is that agreed? Agreed. Shall Amendment 125, already discussed at number 1, is that agreed? Agreed. Shall Amendment 126, already discussed at 68, is that agreed? Agreed. Shall Amendment 127, already discussed at 68, is that agreed? Agreed. Shall Amendment 128, already discussed number 3, is that agreed? Agreed. Shall Amendment 129, already discussed at 23, agreed? Agreed. Shall Amendment 130, already discussed at 178, is that agreed? Agreed. Shall Amendment 131, already discussed with number 3, is that agreed? Agreed. Shall Amendment 132, already discussed at 78, is that agreed? Agreed. Shall Amendment 133, already discussed at 78, is that agreed? Agreed. Shall Amendment 124, already discussed at number 6, is that agreed? Agreed. Shall Amendment 135, already discussed at number 6, is that agreed? Agreed. Shall Amendment 136, already discussed at number 6, is that agreed? Agreed. Shall Amendment 137, already discussed at 73, is that agreed? Agreed. Shall Amendment 138, already discussed with 73, is that agreed? Agreed. Shall Amendment 139, already discussed with 73, is that agreed? Agreed. Shall Amendment 140, already discussed with 73, is that agreed? Agreed. Shall Amendment 141, already discussed with 73, is that agreed? Agreed. Shall Amendment 142, already discussed with 73, is that agreed? Agreed. Shall Amendment 143, already discussed with 73, is that agreed? Agreed. Shall Amendment 144, already discussed with 73, is that agreed? Agreed. Shall Amendment 145, already discussed with number 1, is that agreed? Agreed. Shall Amendment 146, already discussed with 68, is that agreed? Agreed. Shall Amendment 147, already discussed with 68, is that agreed? Agreed. Shall Amendment 148, already discussed with number 1, is that agreed? Agreed. Shall Amendment 149, already discussed with number 1, is that agreed? Agreed. On Shall Amendments 150, 150, 165 to 169 inclusive, and 171 are related and will be discussed together. I call on the Minister.
These amendments deal with Chapter 5, Part 3, which provides for offences under the bill. The purpose of Amendment number 165 is to provide that Section 122, which deals with breaches of a debtor's obligations under a debt relief notice, will be broadened to also cover breach of obligations under debt settlement arrangement or personal insolvency arrangement. Amendments number 166 and 168 are drafting amendments to sections 123 and 124, firstly to correct cross-references to other sections of the bill, and secondly to seek to prevent any possible erroneous interpretation of those provisions, as meaning that a person who commits an offence under those sections can only be prosecuted while the insolvency arrangement remains in effect, and not after it ends or is terminated, even if the wrongdoing only comes to light then. Amendment 167 aims to provide more clarity as to what is intended to be published by Section 124, which deals with fraudulent disposal of property by a debtor. I would ask that the House again note a slight typographical correction to Amendment 167, which is that the reference in subsection 2 to subsection 4 should in fact be a reference to subsection 3. and I would ask the House to agree to the typographical error being amended. Amendment 150 reduces the amount of credit that a debtor may seek without informing the creditor of the fact that he is party to personal solvency arrangement to €650. This is the same amount as has been provided for in relation to the debt relief notice and debt settlement arrangement. The purpose of Amendment number 169 is to bring the offence provision in section 125 into line with those restrictions on a debtor who seeks to obtain credit of more than €650. Amendment number 171 proposes to amend section 127 to increase the fine for a summary offence under the bill to a class A fine, which means a fine not exceeding €5,000.
Question is that shall Amendment 150 be agreed? Is that agreed? Agreed. Shall Amendment 151 already discussed with 73? Is that agreed? Shall Amendment 152 already discussed with 73? Is that agreed? Agreed. Shall Amendment 153 already discussed with 73? Is that agreed? Agreed. Shall Amendment 154 already discussed with 73? Is that agreed? Shall Amendment 155 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 155 already Shall Amendment 156 already discussed with 101? Is that agreed? Agreed. Shall Amendment 157 already discussed with number 10? Is that agreed? Agreed. Shall Amendment 158 already discussed with number 10? Is that agreed? Agreed. Shall Amendment 159 already discussed with 10? Is that agreed? Agreed. Shall Amendment 160 already discussed with number 5? Is that agreed? Agreed. Shall Amendment 161 already discussed with 101? Is that agreed? Agreed. Shall Amendment 162 already discussed with 101? Is that agreed? Agreed. Shall Amendment 163 already discussed with 101? Is that agreed? Agreed. Shall Amendment 164 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 165 already discussed with 150? Is that agreed? Agreed. Shall Amendment 166 already discussed with 150? Is that agreed? Agreed. Shall Amendment 167 already discussed with 150? Is that agreed? Agreed. Shall Amendment 168 already discussed with 150? Is that agreed? Agreed. Shall Amendment 169 already discussed with 150? Is that agreed? Agreed. Shall Amendment 170 already discussed with 40? Is that agreed? Agreed. Shall Amendment 171 already discussed with 150? Is that agreed? Agreed. Shall Amendment 172 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 173 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 174 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 175 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 176 already discussed with number 6? Is that agreed? Agreed. Shall Amendment 177 already discussed with number 56? Is that agreed? Agreed. Shall Amendment 178 already discussed with 56? Is that agreed? Agreed. Shall Amendment 179 already discussed with 56? Is that agreed? Agreed. Shall Amendment 180 already discussed with 40? Is that agreed? Agreed. Shall Amendment 181 already discussed with number 1? Is that agreed? Agreed. Shall Amendment 182 already discussed with 73? Agreed? Agreed. Shall Amendment 183 already discussed with number 11? Is that agreed? Agreed. Shall Amendment 184 already discussed with 115? Is that agreed? Agreed. Shall Amendment 185 already discussed with 107? Is that agreed? Agreed. Shall Amendment 186 already discussed with 107? Is that agreed? Agreed. Shall Amendment 187 already discussed with 107? Is that agreed? Agreed. Shall Amendment 188 already discussed with 107? Is that agreed? Agreed. Shall Amendment 189 already discussed with 107? Is that agreed? Agreed. Shall Amendment 190 already discussed with 107? Is that agreed? Agreed. Shall Amendment 191 already discussed with 107? Is that agreed? Agreed. Shall Amendment 192 already discussed with number 5? Is that agreed? Agreed. Shall Amendment 193 already discussed with 107? Is that agreed?
One thing, Cathaoirleach, I should point out in relation to amendment number 192, because we went through those very rapidly, and I omitted to mention that amendment number 167 is dealt with later in the text. and it's just important to note that. We didn't speak to that particular issue.
Okay. So
That's the correction of 192.
one time. So within Shannon Amendment 192 is agreed. It's already discussed at number 5. Yeah.
Apparently there's a semicolon out of place. We're anxious to ensure the semicolon is in the appropriate place. So we will come. We'll be coming to the semicolon.
So the question in Shannon Amendment 192 already discussed at 5. That's agreed. Agreed. Shannon Amendment 193 already discussed at 107. That agreed. Agreed. Shannon Amendment 194 already discussed at 107. That agreed. Agreed. Shannon Amendment 195 already discussed with 107. Is that agreed? Agreed. Shannon Amendment 196 already discussed with 107. Is that agreed? Agreed. Shannon Amendment 197 already discussed with 107. Is that agreed? Agreed. Shannon Amendment 198 already discussed with 107. Is that agreed? Agreed. Shannon Amendment 199 already discussed with 107. Is that agreed? Agreed. Shannon Amendment 200 already discussed with 107. Is that agreed? Agreed.
Agreed.
Yeah. Yeah. Do you wish to speak?
May I?
Yeah. Amendment Shannon Amendment 200.
Thank you, Last Corley. Apologies I couldn't be here earlier. We just had the public interest directors in from Permanent TSB, and what we heard is relevant, Minister, to the amendment. Minister, I've supported this legislation the whole way through, and I fully support your intention with this legislation, and fully appreciate your engagement with the Oireachtas on this. The amendment at stake is around the bankruptcy payment order. And what it says is that after the 3 years of bankruptcy, the creditor may apply for an additional 5 years of payments. And the legislation goes on to, the Amendment 200 goes on to confirm that the period in question, therefore, could be up to 8 years, in saying that it can be no longer than 8 years. Minister, for me, the single most important part of what you're trying to do in terms of getting good outcomes at the negotiating table that don't need to go to court is a credible threat from the borrower that says, if you, the creditor, and as you know, Minister, what I'm particularly interested in when I talk to this is the distressed mortgages. If the bankruptcy period was 3 years and the payment order could not exceed the 3 years, it allowed for a very credible threat from the borrower to say, if you, the bank, are not willing to engage in the spirit of this legislation, as the Minister has laid out, and I agree with how you want it to work, I am willing to put myself and my family through 3 very tough years in order to escape this debt. So what I want you, the bank, to do is to engage reasonably and in the spirit of the legislation, and if you don't, I can suck it up for 3 years. And I think that is a credible threat. I believe what will happen now, and people who are dealing with these every day and representing these distressed mortgage holders agree, what will happen now is that when that threat is made, that the bank will say, it's not really 3 years, it's 8 years, because in the last week of your bankruptcy, we can apply to the court for a payment order, and we can essentially keep taking your money off you for another 5 years. And we can debate how that might actually play out, and indeed your intent for how it might play out. But at the negotiating table, where you've got the bank on one side and you've got a distressed borrower on the other side, I believe that that threat from the bank, where they'll be able to reference these 3 paragraphs, and I refer to page 61 of the amendments. It's the first 3 paragraphs of Amendment 200. I believe the bank will get away with a counter threat that says it's not 3 years, it's 8 years. And your kid is entering primary school this year. By the time we're finished with you, your kid will be entering secondary school. And that for an awful lot of men and women in Ireland who desperately need to use this legislation, the banks will successfully stop them from doing so, because 8 years is no longer a credible threat. This is backed up by Richie Boucher's comments yesterday, where he essentially said, we're not going to engage with this legislation. we are absolutely not going to engage in surrender of debt. He's on the record, he's in the media reported as saying that. We've just had the two public interest directors in from Permanent TSB, and Deputy Doherty and myself questioned them on what the bank is going to do in terms of debt surrender, specifically in the context of this legislation. And Ray McSharry said, quote, "There will be no debt forgiveness, none." And he repeated it in various ways. And I have to say I was shocked. I wasn't shocked to hear Richie Boucher say it, because Richie Boucher is acting absolutely rational as the chief executive of a private bank in saying his objective is to maximise return to the bank. It's not to better society. That's your objective and our objective. I was shocked to hear one of our public interest directors say it. I asked him, I gave him a specific example and said, okay, if we have a borrower who borrowed 400, the house is now worth 200, and she could service 250. This is very similar to the example you and I used, Minister. In that case, are you saying that it is the position of the bank that you will not write off or forgive or surrender the 150,000 to leave her with a mortgage which she can afford, leaves her in the house, and still leaves the bank in a better position because the mortgage is 250 versus a market value of 200? And he refused to answer the question. He refused to engage in the question. It's all on the record. It's all there. It's just happened. And Minister, based on, rather, my position on this has always been that legislation which requires banks to voluntarily surrender this debt isn't going to work. The comments by Richie Boucher yesterday and the comments we've just heard from Ray McSharry absolutely back that up. And I never had the faith in the senior managers of the banks, the boards of the banks, to voluntarily surrender debt, as is your intention in this very well-meaning legislation. Amendment 200, to my mind, and I say this with huge regret, I think this could be the most important piece of legislation that your government will produce in its term. And I absolutely believe that in the context of the comments we've heard just now and from Bank of Ireland, that Amendment 200 neuters the legislation. Because no matter what Ray McSharry said, or no matter what Richie Boucher said, and I believe that the other banks will act in exactly the same way because they are acting rationally if they do so. They're defending the interests of the banks. It didn't matter if the borrower could say, you know what, we appreciate you don't want to surrender any debt, but we'll walk away. We'll give you the keys, we'll go into 3 years of bankruptcy, and we're going to walk. The amendment which Senator Crown tabled in the Senate would have limited the payment order to the 3 years of the bankruptcy. And I've no problem with a payment order. You could have someone on a wage of €80,000 who could pay the creditor some amount during the bankruptcy period. I've no problem with the principle of a payment order. But Amendment 200 extends that in real terms. In the mind, we can argue the technicalities if it's not really an 8-year bankruptcy period, the 5 years is something else. But at the negotiating table, in the mind of a distressed borrower, they're going to see an 8-year period. And it is with huge regret that I believe that Amendment 200 will render your excellent intent on this legislation largely defunct. So it is for that reason that I'm going to oppose it. And I know, Lascan Corla, that the minister is not in a position to accept amendments because they'd have to, it would be a change of policy and he would have to go back to the cabinet. And my understanding is that this is meant to be going to the Ors this evening. So I understand that what I'm saying right now is not going to change the legislation. I absolutely believe in what you were trying to do, Minister, and I've supported you publicly and privately on this the whole way through the legislation. And at the last hurdle, I am going to oppose it, again with huge regret, because I believe that the banks will use Amendment 200 to negate what this is trying to do. And For me, as a public representative, I need no greater proof than the comments from Richie Boucher yesterday and the comments from Ray McSharry in the last 2 hours. And I say that with genuine regret. Thank you.
Come on with the Seachta. So I call on the Minister here.
Well, firstly, I'd like to thank Deputy Donnelly for raising this issue. And I would like to thank him also for his constructive contribution throughout to this legislation. I'm anxious to ensure that there isn't a misunderstanding about Section 200 and to avoid, I hope, creating too much boredom in the chamber, I'm going to repeat something I've said previously, and I appreciate the Deputy giving me the opportunity to do so. I, of course, haven't heard the presentation that the Deputy makes reference to with regard to Mr. Ray McSharry. But let's just look at what Section 200 or Amendment 200 does and its implications in relation to the legislation. And it replicates something that's already in bankruptcy law that the Deputy will be familiar with. What effectively we're doing in this legislation, and let there be no doubt about this, is prescribing a period of 3 years bankruptcy. And the only circumstance in which bankruptcy is extended, to paraphrase the legislation, is where there's been a fraud on the behalf of the debtor, or there's been a clear concealment of assets, which may lead to the bankruptcy period itself being extended up to 8 years. That's the only circumstance which the bankruptcy period can be extended. So there's no question of this section extending the bankruptcy period from 3 to 8 years for individuals who haven't engaged in fraud or haven't concealed assets. So I think it's very important to get that message across. This is not a provision which is going to turn what is to be a 3-year bankruptcy period into an 8-year bankruptcy period, and it doesn't do that. Quite clearly doesn't do that. Now, what does the section do? The section contains a provision within it which allows for the official assignee in bankruptcy to seek something called a bankruptcy payment order by way of application to the court. And the circumstances in which a bankruptcy payment order may be sought are where, during the course of the 3 years of the bankruptcy period, an individual's financial circumstances might substantially improve, and there may be a valid ground for arguing that post the bankruptcy it's reasonable that they continue to discharge some element of the outstanding debt that hasn't been discharged during the course of the bankruptcy. That application might be made, the official assignee may be asked to pursue that issue by any creditor. It doesn't have to be a financial institution. Let's always remember what we're dealing with here is insolvency legislation. The area the Deputy is concerned about is, of course, of particular personal concern to me and the government. But let's start off from the perspective, this is insolvency legislation. So there may be, in the context of insolvency legislation, where monies are owed to creditors, other individuals who are just barely financially hanging on and who, during the course of the bankruptcy, have not recovered a reasonable portion of the debt that's there. But because of the improved circumstances of the bankrupt, there is a fair and reasonable prospect they may get something additional. And of course that could apply to a financial institution as well. The first thing is the official assignee has a discretion as to whether they make that application. And the second thing is they have a discretion as to for how much they make that application. So this is controlled by the official assignee. Thirdly, the courts, it'll be for the courts to determine how to deal with these applications. And they must deal with them in circumstances in which individuals who have now exited bankruptcy, once you've exited bankruptcy, you don't have any of the constraints or difficulties of being a bankrupt that accompanied you. You are actually free to get on with your life, to create another business, to generate income in whatever way you choose. And if you're successful in that, it may be that it's only fair and reasonable that you discharge some additional portion of debt. And there will be circumstances where that's appropriate, and there will clearly be all sorts of circumstances where that is not appropriate. From the perspective of a creditor, whether it's a secured or unsecured creditor, whether it's a financial institution or someone else, there's no guarantee of the outcome of making any such application to the courts. So this isn't, we look for it. The official assignee, firstly, may determine it's not appropriate to make the application. The courts may determine, even when the official assignee does make the application, it isn't appropriate to make the order because there's a particular philosophy about this legislation. Particular philosophy is that people are given genuinely a second chance. Now, a second chance to get on with their lives and exit from the financial difficulties they were in. And of course, people must be given an incentive exiting bankruptcy to get on financially successfully with their lives and not to find themselves put into further penury. That's all very important. Now, this legislation, as the Deputy fairly and correctly says, is based on a certainty approach. It's based on an approach, in particular dealing with the personal solvency arrangement, which deals with secured credit, where it's perceived that there is an incentive for all creditors, including financial institutions with secured debt, to engage constructively with the personal solvency practitioner to see can an agreement or resolution be reached. And for a whole range of reasons, bankruptcy may be a very bad alternative, as much for the financial institution or other creditors as it is for a debtor, because a debt settlement or personal solvency arrangement may, over a period of years, create a greater possibility of recouping some of the debt due and may create greater opportunity for the debtor to exit the arrangement. From the financial institution's perspective, the bankruptcy will produce an inevitable sale of the home. This may not be something that the financial institution wants to achieve, for a whole range of reasons also. And if they travel the route of repossession as opposed to bankruptcy, there may be substantial downsides if you did that to any great extent. And the Deputy is aware of those, and I won't delay the House by going into those. So, in the context of this has been a mechanism that's part of bankruptcy legislation in other jurisdictions and for a long time. And it remains part of this structure. But to suggest that it creates a bankruptcy period of 8 years instead of 3 years is incorrect. And all of the constraints that come with bankruptcy are lifted from an individual. So to some extent, how this will work in practice in the context of the new arrangement that's there, or how it might impact on discussions and negotiations, is greatly a matter for conjecture. But let me say something yet again with great clarity, which is this. The personal insolvency arrangement, in circumstances in which we have tens of thousands of people in this state who are, in regard to home mortgages, in significant personal financial difficulty, individuals who might have been part of two-income family households, which are now part of one-income family households, individuals who may have been self-employed in businesses that were successful in the first part of the 2000s, but they're barely eking out a living today, individuals whose assets have collapsed, God help them, they might not only be in negative equity, but might have invested whatever savings they had in bank shares, which have completely gone down the toilet. There are a lot of individuals in this state, through no fault of their own, caught in a debt trap. There are some individuals who are caught in that debt trap through their own irresponsibility. Not everybody is there for reasons beyond their control. But there are thousands and thousands of people who are there for reasons beyond their control. They've been hit by a fiscal and economic tsunami. Individuals who perceive themselves as being in secure employment found themselves unemployed, never expecting that to be the case. Individuals who were running businesses that appeared to be successful because of the failures of others to pay debt have found themselves in debt with some businesses, whether they're companies going to liquidation or non-corporate businesses, SMEs, single ownership businesses that have been wound up. We have a lot of people in trouble. And there is an issue. And the issue is the banks must constructively engage with this legislation. And as I've said, in the context of personal insolvency arrangements, there are options for a financial institution with secured debt, be the secured debt a home loan or another form of loan. And that is that based on the individual circumstances of the debtor concerned, the arrangements will clearly have to be put in place that are either debt forbearance or which involve some aspect of debt forgiveness. There's no doubt that we know the financial institutions will engage in debt forbearance. We know there's in excess of 80,000 homes at present, in respect of which 80,000 individuals in respect of homes, 80,000 loans, I should say, in respect of homes, where there have been debt forbearance arrangements put in place, some of a temporary nature, some of middle, longer duration. There are individuals who have benefited from debt forbearance arrangements who have now worked themselves out of that, and they're actually paying full capital and interest. The whole area of that's a focus is debt forgiveness. Will the financial institutions, where you have individuals who are genuinely insolvent, who can't pay their monthly repayments as opposed to won't pay, or burdened by other debts,